All right. Thank you guys so much for all getting on the right one. Sorry about the last minute change. So we had a little technical difficulties, but I'm glad that we're all here now.
Yeah. Well, yeah.
Alex, that's a great photo on there. I've never seen that one.
Oh, thanks, Gabby. Yeah, was made a couple years ago already, and I'm using my like 6-year-old photos from law school still on my on my email. I gotta go and make photo session. My wife told me to do that many times, but usually she's ordering for her or for the baby, and I'm left behind. So that's why still old pictures. Oh, gotta update it definitely, because yeah, I think I look wiser right now. So
Much wiser
before. Yeah, I've been through a lot for the last 6 years already at work, so that reflected definitely somehow on my face. Not wiser, older, but still, just want to be a real person.
Love it.
Right. And Ben, I heard you saying something, but you were you're muted. We didn't hear what humorous anecdote you levied upon us.
I know. Ben was making a joke. Oh, want to tell us a secret?
Yeah,
How to preserve
you
the
look
face.
great. The goatee.
What the
I'm trying to
secret?
see if I can grow one. No, it never grows on my face. You look great. And you haven't gained any weight, though. That's the point. You know, the COVID-20, whatever, the freshman 20, the COVID-20.
And he doesn't eat anything.
Yeah, John knows my.
Alex is raw vegan. The guy is the healthiest eater in the history of the world.
I know. It's about what you eat, man.
That is so great.
Raw vegan diet, and I hope John had a chance to try those raw vegan cookies with Pam.
Yeah, they were very nice. Very nice raw vegan cookies. But Alex, I go the other way. Because you're not eating enough pizza and drinking enough beer, I decided to eat yours.
Your portion, yeah.
Someone's got to do it. Taking one for the team.
Right. You know, the pizza industry is taking it hard because Alex won't eat any pizza.
Once the friend of mine came and he brought me to the pizza place and actually talked me into eating pizza with cheese. I didn't eat cheese maybe for 6 years, and I agreed. My face swole next morning. I had a picture somewhere. When I showed it to people, they were like laughing their ass off. They didn't believe, like seeing me and my face like 10 bees bite me off. I wouldn't even open my eyes, so much I got swollen because of the cooked cheese and everything. So it's for real. I mean,
cheese in the U.S. for 6 years. Wow. I don't know how you avoid cheese.
Yeah.
That's basically how heavy food we're accustomed to, and I have a right to say about it because I'm Ukrainian myself. Our dish is like feet speck, fried with onions. You have some potato over there, and that's what I was eating all my life. Really, I had a severe acne actually issue because of that. Now I just realized because of food which was not really compatible, and my bronch like to the skin, all that fat and oil. I didn't understand what's going on. As soon as I actually stopped, it helped me a little bit to fix my skin, because before it was like disaster.
Yeah,
it's also fascinating, isn't it?
Yeah. Okay, let's jump in this week. We had a really good session last week. Unfortunately, we didn't record it, but I thought last week was really good because what we had is an opportunity to go over with how to use Visas.AI as a tool. Ben, you've become much better at it in every day, really. Pretty fantastic, and we got to go through this. So why don't we? So just sort of an agenda. We'll talk about what were the things that we wanted to cover last week, our issues, and then we'll decide on a topic for this week, and then we'll go forward on that and have some takeaways. So anybody have any takeaways or to-dos from last week? We have anything on that? Emma, did you have any in your court?
I did not have any in my court from last week. But
you had been engaging in some conversations with and others. What has that been like?
Well, honestly, the last week I haven't had conversations with them. I had that phone call with. I think she's looking forward to hearing more from me. So it's a good time to circle back, with her. And
to bring you up to speed, we've decided to. Alex, have you now finished the last case, or do we have one more? Do we still need to file?
No, John, we filed everything on time, even 1 day earlier, so we made it.
Yeah. So we've hit all our deadlines. We did 9 cases, including one we did for our guy for free. So I'm looking at it as a good experience, and I think we've built a really good program. So what that, as soon as we get our letter signed, what that's going to allow us to do is we will no longer be bound by an exclusivity, so that we can go out and talk to others in a couple of capacities. One, any overflow cases we may want to do, or two, licensing them our software so that they can do their cases better and more efficiently. And I'm open to all of that. So Gab, we want from you, your to do is to find the name of that person. What we're seeing, Montana or Wyoming. Okay, so we'll reach out to her. And Emma, maybe we should start a conversation with Pear to see if there is any synergy there. And Evelyn, if you know of anybody that's
You mean Elisa?
Elisa, yeah, that's okay.
I knew that. Sorry, Melissa. If you know of anybody that you think we should be working with in either of those capacities, I think we've developed some really good strategies. I think we've developed some excellent documentation. And we could help some folks. And we might just reshape how we're going to do it, right? I mean, I think we'll have a little bit more flexibility with price, significantly less, because there's not a Giuseppe price on top of our price to be able to do some stuff for some folks. But Alyssa, anything on your side that sounds interesting out of that?
Let's see. I've been kind of diving in a little bit on prosecutorial discretion.
Mm-hmm.
There's been a trend in the courts of just bypassing the master calendar hearings and scheduling for individuals or whatnot. And that allows for counsel to reach out to OPLA for prosecutorial discretion after the Trasvinia memo. And so I've been kind of diving into that, and it's been very interesting.
So tell us a little bit about that. What is back that up a little bit, and tell us what element of immigration is that? What is prosecutorial discretion in? What was the standard before? What's different? What is this memo? And take us. Let's use that as a talking point for today.
Sure. So the area where prosecutorial discretion comes into play is when a person is in removal proceedings, meaning like a deportation case.
Right.
And prosecutorial discretion is where you reach out to opposing counsel, meaning the government, DHS or ICE, in order to exercise discretion and terminate proceedings while the respondent and the person in removal proceedings seeks other alternatives. So, for example, that would come in handy if someone has been granted deferred action for whatever reason, and in order to pursue permanent legal status in the United States, they can seek prosecutorial discretion to have those removal proceedings terminated, and they can then, pursue permanent legal status.
Oh, great. And so this memo that you talked about, tell us what the memo says and what it replaced, and whether this is a positive thing or a negative thing.
So the Trasvinia memo is definitely, it's either a positive or a negative depending on the circumstances.
Right. Okay.
Yes. So the Trasvinia memo, what it basically changes is the format and the weight of the decision making. So basically, the Trasvinia memo lays the discretion to terminate proceedings on OPLA, on opposing counsel. And the courts basically hand over that discretion in terminating proceedings when there's an agreement with opposing counsel.
Okay.
Can you spell this memo again? I'm looking for it. I cannot. Can you spell it for me, please? Alisa, do you mind?
Yes, the Trasvinia memo is TRAS V.
Trasvinia, I got it. Okay.
Trasvinia, yeah.
It was more like Transylvania memo. I was like, what's
Yes. And you can definitely find those guidelines for prosecutorial discretion at the ICE website.
Mhm.
They usually have updates on their guidelines for, for prosecutorial discretion. So it's definitely more informal now. You can just reach out by email to opposing counsel and request prosecutorial discretion, along with, depending on the circumstances, a joint motion to terminate proceedings.
Excellent. So it allows, seems like, more discussion with
But
immigration.
hold on, Alyssa, isn't the Doyle memorandum replaced trans-venue memo? I think there was a Doyle memorandum on 25th of April 2022.
Oh, yes, that's
I
correct.
think that replaced it, and the Doyle memorandum gives that priority for removal and takes as a priority from the people who don't have criminal offenses, who's here more than 10 years, who has the qualified relief. And basically, based on that memorandum, there is a good possibility to get prosecutorial discretion with no criminal history clients and just close it and let them adjust the status. But just Transvinia, I didn't hear about it, but I think I came more to that world of drafting after Doyle memorandum.
Yes, so you're correct, Alex. I apologize. The last I remembered was the Transvina memo, but you're absolutely right. And the guidelines again are on the ICE website, along with the email for opposing counsel.
Okay, so Alyssa, for attorneys that haven't dealt with much of the court-based immigration, was this a movement where it was exclusively in the purview of the courts and is now, while it's prosecutorial discretion, allowing the attorneys to work with the either U.S. attorneys or USCIS officials to come up to a negotiated situation where they didn't have that possibility before, or was there some level of that always?
There was some level of that. It obviously changed under the Trump administration, where the Trump administration tried to limit closures of removal proceedings. And under the Biden administration, that's opening up a little bit more. So, instead of just having the court have exclusive discretion over it, it has turned over somewhat to the government side in order to do that.
So a little more like a criminal court where you can negotiate with a DA or city attorney. And if you come to a conclusion, then great. And if not, you still have the court to make the resolution. Is that?
You're exactly right, John, just because of the amount of prosecutor of the work thinking in his head and amount of relief possible and making this determination not to pursue it at all. And there is no persecution, the case is closed. So they give them that discretion basically to say this file, like, it's a waste of my time. It's no priority, no criminal records. I just want to close this removal proceedings, not close the court. And it's possible for something like that.
Very interesting. Thank you, Alyssa. Thanks for bringing that up. That's fantastic and great add-ins, Alex. Way to pull up the memo. Look at that. That's really what I love about these sessions. Okay, let's then change. I want to talk about a subject today. I don't know. Have I ever told you guys about the litigation that I'm involved with USCIS right now? I brought that up. I know. Alex, did you know that I was suing USCIS?
Oh,
Wow.
I think I touched some case where you were suing someone, but I'm not sure if that's one.
Yeah, I think you may have. So I've filed a lawsuit against USCIS in San Francisco on behalf of my client under the EB1. Really interesting case, and I thought I'd take you guys through it just because it's lawyerly interesting, and I don't really talk about it much with the case managers because that's not really what they deal with, right? And I did this one exclusively without any of the help of the squad, so or our case managers in our team. So this was a case of an EB1 that I filed for an AI architect that's working at Facebook, makes a lot of money, like more than $350,000 a year. He's been selected into a very elite AI membership. which had outstanding achievements, a group of some of the best and brightest AI developers and architects from some of the biggest companies in the world. What they're trying to do is create an open source AI community that would effectively run our biggest corporations with artificial intelligence that is, again, open sourced, right? Meaning that anybody can use it, work with it, do it, stuff like that. So a really cool endeavor. He's part of that. He did the judge of others on helping select people to that community. He has been in hackathons. In any case, end of the day, this was really unique. And Ben, maybe you've seen this or not, but it's very rare for immigration to deny an EB-1 if they think you've met the 3 qualifications. In this instance, they said they met 4, right? So they said that they met 4 qualifications of the EB-1, which, and to talk to people that don't know that, or that may listen to this later. So the EB-1 has a series of criteria, or I guess criterion, that if you meet 3, you then go to a second thing called the totality of the circumstances, right? So really just meeting the 3 in itself isn't enough. That's what we always say, but you must have risen to the top of your profession. Okay, so they said he met 4. They then, in their very, very short denial, talked about why he didn't meet the other ones in quite lengthy scenario, but then they said that he didn't meet the totality of the circumstances. So I read the words totality of the circumstances, meaning that you pull from all of them, right? It's the totality. But what they did was created an upper echelon of criteria on top of the criteria below, which I've never seen before. And then looked at them individually, which I think is not the totality. So, for example, they said that he was in 2 memberships, but 2 wasn't enough, right? So they made up more restrictive requirements on top of the regular requirements instead of creating a totality situation. And what I think they did that was fatal, why I sued them, right, is that how these cases work. And I think this will be helpful to talk about as attorneys, because if you know this, it helps you understand how to build a case, right? So when as litigators, you want to say, how can I win the lawsuit? And then I'll settle because I know what it takes to win it and where the pressure points are, right? Well, immigration, I think a lot of us in our profession get into a table of contents and put it up there and they leave it for immigration to interpret. What I think the smart way is that you want to lay out for them, here's how I would litigate if you go against me, which is what we do, right? That's what our briefs do. That's why we have case law and other authority saying that. And the really cool thing is I did all of that, right? Okay, including an element on expert testimony under the Visas.AI case under that case, it says that expert testimony is evidence, right? So in this case, why I think immigration made a mistake is that they did not analyze why the evidence that we provided them didn't meet the standards of, 1, what were the standards of totality of the evidence? Number 2, even in their made up new standards that they had, they didn't go through it. They just made conclusions, right? So, for example, we had experts that went through and talked about some of the projects that this guy had designed. And one was a really, really robust AI project for Ernst & Young, where they took all the AI projects they'd ever done, put it into one system, and then used it. And they said, to the point that the numbers escape me, but phenomenal amounts of transactions on a daily basis, weekly basis. Millions of users are touched by this. Hundreds of millions of dollars have been made or saved by what this guy did. And an expert went through it and talked about it. He called it the democracy of AI, meaning that he has made AI more usable by more people. And he went into such in-depth analysis of what that was and why it was so impressive. And 3 or 4 different people talked about that. They didn't give it any analysis. They didn't talk about the evidence. They didn't talk about the expert opinions. Okay, so what we are dealing with when we deal with agencies is a law called the Agencies Procedures Act, the APA, right? And if a federal official doesn't operate within the scope of their job, then they're in violation of the APA. Does that make sense? So the term is called they're arbitrary and capricious. So when you sue them, you have to say this violates regulation number, or I'm sorry, the statute number of the APA, because it's an arbitrary and capricious determination, right? So the reason that this decision was arbitrary and capricious was that they didn't provide analysis. They didn't talk about the experts or give the experts any credence or disagree with the experts, right? So if they had gone through all of the evidence and looked at the experts' opinion and negated them all, they would have had the discretion to do it, right? But because they didn't, they're in violation of the law, right? And that's why I think we have a good lawsuit. So I filed that lawsuit in San Francisco, and we'll see what happens. What I'm hoping happens, well, we'll see. What I'm hoping happens is that the U.S. attorney says, I see what you mean. The guy didn't do anything, or woman didn't do anything. The officer didn't do anything, and we'll just open it up and approve the case for you. That's what I'm hoping happens. Okay. If they don't, then we would file what's called a summary judgment. And a summary judgment, for those that don't know litigation that well, or those that are listening in that want to know more of it, is where you take the facts that we alleged, and then they answer it and say, okay, we all agree on these 10 facts. We think the law should be applied this way. And they'd say, we agree on these same facts, but the law should apply the other way. That's what a summary judgment is. You don't need to, we're not asking for facts to be determined. We're asking how to apply the law to the facts we agree upon, right? So that's where most immigration cases get done, because it was the application of law upon agreed upon facts, right? So that's where we may go if they don't reopen it and approve it, and we'll see what happens. So it'll be really interesting. I've sued USCIS twice. The other time was on a P visa when USCIS revoked it, not on the particulars of my individual client, but on the league as a whole in professional rugby. And we were able to stay up all night, draft a complaint, and have the owner of a rugby team, who was also a lawyer, walk into the federal courthouse in New Orleans on a Friday afternoon and get a temporary restraining order issued. And so then USCIS had this order, and then what they did is reopened it and approved it and said it was an anomaly, right? So this one doesn't have the pressure on them. They get 60 days to answer after you file suit. And then at that point, we'll see where they're going to do. But they don't move fast. These U.S. attorneys deal with hundreds of cases, thousands of them over their career, and they don't have the same passion that other litigators do, because it's just another case to them. So I'm hoping that they'll find that we could really expose them and make the way you determine EB1s much more difficult for them if we get some case law on it, right? And that's why I think they should reopen it. If not, it would be fun to win that, right? Wouldn't it be great to win the case that redefines how EB1 should be adjudicated? Because I think if it goes our favor, it's going to force them to have to address these things. And what I see in most immigration denials are very conclusionary statements without any real analysis of all the facts that are put into these cases. And we are always fact heavy. We are always expert heavy, and we're always brief heavy. And they think they can just swoop of a pen, make a denial. And this would be a great victory in any case we do it. So that's what I wanted to bring up today. Does anybody have any thoughts on this? Ben?
But John, did you get an RFE first though? So you're saying the lack of analysis came or didn't come, right? Because they just ignored it in the RFE first, and then you responded, and then they denied it. Okay.
Yeah.
Wow.
Absolutely. Yeah. And when I looked at it, there was some discussion on how rare it was that they denied a case that they said first met the qualifications.
Yeah, that's really weird. Right.
The second thing, I had never seen one where they denied it after they felt somebody had made 4, right?
Yeah.
Yeah. So
that's just abuse of discretion. Yeah, that's clearly just some officer, wanting to look tough or something. Okay.
Who knows? We'll see. So that'll be fun. Anybody else want to?
When was this filed? Just curious.
I filed it a couple of months ago. So we're waiting for them to respond.
I see.
60 days. Yeah.
2 days, yeah, it's coming up.
Yep.
Wow, very exciting.
Yeah, well, we'll see. Okay, so that is our issue of today, talking about the EB1, talking about how to brief your legal cases, and that's what one of the strengths of OnlineVisas process is, that we write briefs that that lay it up so that if it is denied, right? I've already said these things. So when I wrote my complaint, I got to say in the initial petition, this argument was made. I raised the argument that experts' testimony had to be given credence under the Visas.AI case. I put that in our initial brief. So when I'm coming back now, it's like, we told you what the law was. And I think that that can really help us, right? So this will be a great victory if we get one for our process, right? And Gabby, this is something that we can use when we're marketing this. And Emma, and if you're helping us get other people to subscribe to this, this will be a great victory if we're able to have used that brief to then litigate when they make this. I think most immigration attorneys never litigate, and I never really conceived of it till that revocation, and then I still didn't really think of it. And I did this one, and I did it on my own dime because the guy's a friend of mine, and he's helping us out, you know, on some other things. And so I just decided to go for it, and it'll be interesting because it is a solution. And to go back to Alyssa talking about the judges and removal, what a judge gives you is somebody that breaks the tie, right? And immigration, as adjudicators, act like the judge and jury, but they do have people above them that can, you know, rule their determinations. And the option most people take is not to go to federal court, but to go to the AAO, right? Which is, to describe what that is an agency judicial branch, right? So it's not the federal courts. It is immigration's own agency appeal process. But that appeal process is pretty interesting and pretty limited, and it takes a long time, right? So they take it off in a year or two. They have no time frames in which to do it, and they very, very, very seldomly rule against USCIS. It's not a never, but I'd like to see the percentage on that. But it is rare. Yeah, and sure. But in this instance, when you get into federal court, they're held to a much higher standard than I think the AAO tribunal holds them to. So this will be interesting to see, to go through the whole process, start to finish, on this.
Amazing.
Yes, it really will be interesting, and it speaks volumes about our belief in our methods and our software to be able to say, look, we really did this right.
Yeah.
you did this
From
wrong.
From the beginning. Yeah, I can't add that. And I mean, to have all the evidence from the beginning stated in the original I-140, whatever. It's so, I'm so rusty on this, John. Remember, like, when now, isn't it when you file like a I-290 appeal, right? Or motion to reconsider? I haven't done one in years, right? Isn't there a rule that you can't add new evidence, right? You have to, they can only look at what was, you can't go, oh, by the way, I forgot this guy's award.
Yeah,
right.
Snapshot of what was in the record, right? It's called the record.
Okay, so that's why it's so important to have everything from the beginning. Yeah, okay.
And so, Ben, what you're talking about, the 290, that is the process to appeal to the AAO. And so that means the agency's court, not the federal courts. You don't have to exhaust and go to the agency's courts first. You can actually go straight to federal court, and you usually have a 2-year statute of limitations in which to do it. So one of the things, as we're building this community, and the collabs are part of the community, and it's really, Alyssa, what some of the things that we've been talking about lately since you last on is OnlineVisas has a product called Visas.AI, which will be, as you know, licensing to other attorneys. And so that puts us in the competition with other software products. But what differentiates us from other software companies is the fact that we were built by attorneys for attorneys.
Yeah.
And one of the services that we provide the members of our community, and I love using that term, is to come on here and talk about your various questions, right? Do you have any questions about immigration? Can we answer it immediately? Should we research it? But every question gives us more knowledge in our database and more perspective. And no software company can compete with that. But what we'd also have is different attorneys that you can have a marketplace and send cases to or whatever. But one of the things that we can do, right, is with your skill set to do some of this removal kind of adjudication that we don't do, is if we have a case like that, we can send that to you. But what we can also do is develop the litigation part of this process. And then other attorneys can use our software, can have a case get denied, can write back into our community and have somebody else in the community litigate that case for them, right? You don't have to do everything. We can together do a lot of different things and share cases with each other. And by sharing cases with each other, what that means is monetizing. Right, so you can bring a case in. I don't have time for this case. I'm gonna kick it over to the community and get a little bit of money for the referral. Let them handle it, and I'll do whatever I do. You know, so those are some of the things that this sort of the future of immigration is this sort of thing. We're sitting in our respective offices, and only Gabby and I are in the same building. You know, Ben's in Houston, and Alex is near LA, and Emma is in the Boston area, and Alyssa, you're in Puerto Rico, right? So that's a wide expanse of different attorneys sitting here talking this sort of stuff. It's really cool, and it never gets old for me to see how we are doing something special and really changing the dynamic of how not only our little corner of the law in immigration is done, but really the law itself. This is unique and special, and how we put it around community with a platform, to me is very, very exciting.
Yeah, I
Sure
completely
is.
agree.
Awesome. Yeah.
It's very helpful, I think, and it really makes a difference because it's sort of a place to bounce off ideas, to get those practice pointers. And like Alex and I were just doing, you know, if someone you know, has better information, then just have that quickly.
That's absolutely right. So that's, I think I saw this stat. I don't know if it's accurate, but it seems accurate, that high 90% of immigration attorneys are in firms of 3 or less attorneys, right? And I bet a really, really high percentage of them are by themselves, right? I was for years. Alex has been, is all of us. Every lawyer in here only works by themselves, you know, or has worked by themselves. And so you have nobody to bounce stuff off of, right? And what happens with that is you rely on, I think it was this memo, and you don't know a new memo came out because you don't have a place. You're not in a big partnership where someone's keeping you up to speed on that. So we have to talk to each other. We have to exchange this. And while we are inventing AI to give us suggestive immigration solutions, that is only as good as the stuff we get and put into the system, right? And it still never replaces us. It can't think, right? It is designed to look like it thinks, but it can't think. And we are in any profession, it's strategy. And strategy is taking information and then using experience, but then other things that you read to make decisions where there are choices of decisions. It's never black and white. It's always shades of gray. And in immigration, those shades of gray are inconsistent shades of gray. We were talking about this today on how we should be giving better service within our firm, right? How should we talk to our clients? And one of the things that we laugh about is people that Google and say, well, I should be doing this and this. And it's really easy to say, oh, come on, your Google doesn't equal my law degree. But you need to be empathetic to them and say, look, you know what? That's really good that you went out and educated yourself. And well done. This makes you a better client because you know more stuff. Let me tell you from my perspective why what you research may be inconsistent for your situation. Number one, immigration's inconsistent. Number two, your facts may be different than the other person's. Number three, you're reading this in such a small microcosm because you don't see the hundreds, if not thousands, or thousands of cases
Other
that
people,
we've
yeah.
had over nearly 30 years, right? I think I've done 10,000 cases. So, you know, with 10,000 cases, it's a lot of data points. When someone has never done a case and they're researching it on Google and they read one thing, what we all know about immigration is that might be right for some part of whatever perspective, but there may be another regulation on another component, or this doesn't interpret the facts that way, right? So one of the things is exchanging ideas, being empathetic to the ideas, and being a master and not being caught up with this is the way it is because this is like I own that idea. None of us own any ideas, right?
Right.
And the next good idea or the next better idea you should adopt 100% of the time, right? And I think so. Having these collaboration sessions where we can talk about that and say, hey, what about this new memo? Is a fantastic exchange of two smart people and two good attorneys coming up to a different conclusion based on new information that is available. And I really love that we had that exchange today.
Yeah.
Yeah.
Very
Yes,
cool.
it was great. I learned a lot from listening to both, to both of you.
Very good. Okay, so what do we think? We can talk about a couple of things. Does anybody have any, let's call this the question section. Does anybody have a question that they'd like answered on immigration today? We can just kind of go around the office. So if you got one, shoot it out. Think about anything you want, something that you've been meaning to look at, request, or maybe one that you did think about and got an answer to that you want to throw out for the team.
So, you know.
No? Well, I have one, and let's see if anybody knows this one. DACA EAD is extended automatically by filing it before its expiration, or does it require it to be approved before they can work? Anybody know?
I'm gonna guess approved.
Okay. What do you think, Alyssa? Evelyn?
One moment. I'm just checking here. In USCIS in the website, they have the categories for automatic EAD
Right.
extensions.
Right.
Oh
Yeah.
yeah.
I'm just checking if DACA is one of them.
Yeah.
So it's looking like they would have to renew their EAD before it expires.
File the renewal before it expires, but
Yes.
do not have to wait for the approval. They are one of the categories that gets automatic revalidation if filed prior to expiration. Is that what you're saying?
No, I'm saying that it's not in one of the categories that has automatic extension. So they would need to affirmatively renew their employment authorization.
It would needs to be approved, is what you're saying.
Yeah.
Filed it. She filed it before expiration. Okay. So what, and Ben, that's why your guess was interesting, right? Because a fairly recent law during the Biden administration, right, was the extension of EAD cards. So all EAD cards before the Biden change had to get approved before they could continue to work, right? So we were saying, well, you had to file within 120 days.
Right, 120 days.
COVID came and the Trump administration came and it got delayed, right? So it was taking far more than 120 days to be able to get those extensions. So what they did, interestingly, is created certain EAD cards would get extensions, would be automatically extended if you filed before the expiration, but not all of them. So what Alyssa just did is looked up which ones did. And Alyssa, do you mind sharing that on the deal? Let's capture that that website for our files, for our knowledge. So it looks like Alyssa has researched that this person will have to wait to get approved before she could start work.
Mm-hmm. Yeah, I can go ahead and share that.
Okay.
Okay. Are you able to see me?
Yes.
Okay.
Yes.
So here we have the USCIS website.
Mhm.
And it explains that certain renewal applicants who have filed Form I-765,
Mhm.
application for employment authorization, qualify for an automatic extension of their expiring employment authorization, which is what we were talking about.
Mhm.
And so underneath here, we have the eligibility categories for automatic extension. We have refugee, asylee, N8 or N9, citizen of Micronesia, Marshall Islands, or Palau, withholding deportation or removal granted, TPS, spouse of principal E non-immigrant with an unexpired I-94, spouse of principal L1 non-immigrant with an unexpired I-94, showing L2 non-immigrant status, asylum application pending adjustment of status, suspension of deportation filed before April 1st, 1997, cancellation of removal, special rule cancellation of removal applicants under NACARA, creation of record, adjustment based on continuous residence since 1972, pending initial application for TPS, where the person is prima facie eligible, Section 210 legalization, Section 245A legalization, life legalization, spouse of certain H-1B principal, and VAWA self-petitioners.
Okay, let's see if scroll down below with the asterisk, and let's see if there's any discussion of DACA there.
So it just talks about for more information on the options available to demonstrate employment authorization for e-spouses and L-spouses. Individuals with TPS-based EAD may receive an automatic extension of their EAD through publication of Federal Register notice or through automatic extension. Then it talks about F1 students who have a pending STEM optional practical training.
Okay. Let's scroll down below and see if there's anything else below that. No. Okay, scroll up a little bit before it gets to the chart. No, I mean above the chart.
Okay.
Okay. Keep going right. Okay. So here we have Emma's sort of, not you, Emma, but this Emma, sort of over it. But it says to present acceptable proof of automatic extension of employment and or EAD, you can show your Form I-97 along with your qualifying ED of your unexpired Form I-94 if you are an H4, EL2, including E1S, E2S, E3S, and L2S class or admission codes. Document containing sufficient proof up to 540-day automatic extension. Yeah, so no reference to DACA there.
That can't be right, though. This is all about DACA, right? This automatic extension is really for they've got to be the primary.
Well, no, all these other folks have them. Matter of fact, that what they're doing is excluding them, and I don't know why they would have excluded them. But the ones that were complaining the most about it are H4s, ELs, right? Those are people that have to work, and then their spouse would get their visa extended, filing it, and sometimes they couldn't file till the end for various reasons, and then they were stuck and had to quit their jobs, right? So
right.
That's who was protected. For some reason, in the genius of discretion, someone said, "Well, not these DACA kids. They don't need to do it. Let's leave them out." Right. So that's pretty interesting. So, Gabby, we're going to have a conversation about that with our new employee because they may not be able to.
Yeah. So I was reading up a bit and just kind of the logistics behind not including DACA. It really is a consequence of the Trump administration wanting to eliminate that program altogether. It seems like the Biden administration still hasn't caught up on fixing that issue if it plans to at all.
Is there any discussion anywhere else about DACA recipients being protected somehow, notwithstanding this regulation that doesn't give it to them? Have you seen it, heard it, any discussion about it?
Not for employment authorization. I do know of some news regarding litigation for DACA, like federal litigation for DACA, that that seems like a big win for them, and just protecting the program overall. So far, people with DACA are still able to renew and are still able to, have all of the benefits under the program.
Okay. Let's see. I'm gonna do a little research here. We got 5 minutes. This will be the last thing we do. There's some information on it, but I don't know that it
should be. Man, it should apply to
This is referencing March 4th, 2021, completing Form I-9s with extended work permit for DACA extensions and extensions for permanent residency. Applicants from deferred adjudication child arrivals, DACA, receive a work permit in the form of an EAD card, subject to timely renewal. Owing to COVID-19, the United States or USCIS is facing substantial delay in processing EAD applications. DACA recipients were in limbo as the delay in processing threw them out of work. To remedy this situation, USCIS on January 21st, 2021, issued a release advising employees how to handle this situation for the purposes of completing Form I-9 employment eligibility requirements. Now employees can use their expired EAD card along with an I-797 extension notice for verification as a valid work permit.
Okay.
Completely in opposition of what you just read, right?
Yeah.
Employees must enter the validity date of the employee's notice and the expiration date field in section 2 of the form. Additionally, they must enter DACA extension and additional information. Employers can also re-verify current employees before re-verification is required, and their employee presents this combination of EAD, category 33, and an I-797 extension notice. Employees must enter the notice expiration date in section 3. All right, so that's interesting. Let's go up to, there is a January 21st, 2021 memo. Let's see what that says. January 21st, 2021 memo, DACA extension EAD. Okay, here's something. Considering of deferred action for childhood arrivals on, I wish I could share my thing. Let's know what we need. Sorry, we're getting there. We got 1 more minute.
Are we still here?
Yeah, I'm reading this thing. I'm sorry, this isn't great
Okay.
stuff.
It's noon, so do we want to wrap up?
All right, well, let's wrap up. I'm looking at this, but guys, it looks like there may be something in January 21st, 2021. I'm reading that was a date that Biden issued an executive order regarding DACA, and while it was continued to be there, then it has a frequently asked questions. My to-do for next week is to come back with this answer on whether or not that can happen. We'll see, because we're going to need to make that decision in our firm and see what happens. So we'll return on that. So everyone, thank you so much. That was a great session, and lots of good questions, answers, and analysis. So we'll see you next week.
Thanks, guys.
Awesome. Thank you very much. Take care, everyone.
Everybody.
Bye.
Bye.
Thank you, man. Gabby, talk to you. Thank you.